From distant lands we gather, hearts of fire all along. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big because we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. From horizons wild we roam, with thunder in our soul. Every battle brings us home to the stories ages told. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Hey, folks! I made it. Not that I was late coming home, but I might have been late waking up from a really, really nice nap. And yeah. So, hello, folks. Hello, Erin. Hello, Siobhan, Gwendolyn. Hello to everybody. Hello, YouTube. Hello, Rumble. Hello, you over at X. Hello, folks. Today is going to be a bit of a combination. Combination. We are going to talk about what's going on with my StreamYard. Why are you being naughty with me? Oh well, it seems to work. If you experience some hiccups, let me know, because I'm experiencing some hiccups over here at my end. But my end, it's not important. The important thing is that you hear me and you see me. So, yeah, bunch of stuff. Fani Willis on vacation with Nathan Wade. You remember that guy who she claimed she broke up with before she handed over somewhere between $700,000 and $1 million, or just happens to be on vacation together? And Georgia Senate or Georgia Congress, whatever it is, has had a hearing about her earlier today. So that's interesting. Then we have a new hearing in the Donna Adelson case. Then I'm currently searching for, because there's supposed to be a new filing in the YNW Melly case, which of course I need to go through it with you guys. And what else is there? What else? Slidey Pie over at Rumble is here. Hello. There was something else as well. I'm not entirely sure. But we have a good program. I hope we can get ourselves busy. And yeah, let's start with, let's see, this one. Dun, dun, dun. Whoop. Let's see here. Well, from the Daily Mail. Scandal-plagued couple whose affair, but it's not, rocked election scene together for first time since, well, that's not entirely true. For first time since what? Because we saw her and Nathan Wade, not that, about, what was it, 2 months ago when Fani's daughter, I believe it was, got pulled over on the interstate outside of Atlanta. Of course, she wanted her mom, and nothing there. And so the cops were nice enough to, hey, let's call mom here. Who's mom? Well, it's it's District Attorney Fani Willis, and she shows up with Nathan Wade. Now, Nathan Wade and Fani Willis officially lives in different places in Atlanta, somewhere between half an hour and 45 minutes away. And even though they supposedly live apart, came in the same car, just maybe less than half an hour. So yeah, they haven't broken up. Nah, nobody believes that. Just because she said it in court under oath, you actually think she wouldn't lie to you? I mean, she's been lying for years about her relationship with Nathan Wade. She lied about it in church. So why not lie about it in court? I mean, for Fani Willis, lying is a second nature. And it's, yeah. Well, you all know what I feel about this lying sack. Whatever. How she got reelected? Well, if you don't get many options, they will vote for you. Apparently, in Fulton County, so she can keep living out of taxpayers' money. What else other than that? Well, we talked about also a while ago. She lost 2 cases now, and she owes 2 different law firms. What was it? 54 plus 20, well, close to $80,000, because she believes she's above the law. We also know that. But let's see here. What else do they? Fani Willis and Nathan Wade spotted together at LAX despite previously claiming their relationship ended in 2023. And yeah, there they are, going on vacation. Oh, how nice. How nice. How nice. Being all chummy and everything. So you remember she had this fundraiser or gala, whatever it was, for I got reelected, let's have an inauguration gala, where I think she raked in close to $250,000. And now we know what she did with that money. And here's the thing with Fani Willis. Don't know if this particular vacation is on her own money or taxpayers' money. But isn't it kind of... What does your gut tell you about Fani Willis? It's a district attorney's office that has so far been fined $80,000, which you, Fulton County taxpayers, you pay. And then she goes on vacation. Yeah. Why? She thinks she deserves it. I know she must be under really, really, really much stress of wasting taxpayers' time, wasting taxpayers' money. I mean, that must be stressful. So why not go on vacation with your ex? Yeah. Now, but the timing of this vacation is also a bit interesting because okay, so she lost twice in court regarding the FOIA requests, and she's been dodging a subpoena for what is it, 6 months now? So of course she chose to go on vacation at the exact time as this happens. The Georgia Senate committee pushes for subpoena enforcement in DA Fani Willis probe. So at the same time as this hearing is scheduled regarding what has happened lately, she shows, fuck it, I'm going somewhere. I don't know where she went. Maybe Aruba again. And as you well remember, last time they went to Aruba, yeah, she likes wasting, especially other people's money. She loves wasting other people's money. So, okay, we can now conclude that her claim that they are no longer a couple and have, yeah, it's bullshit, folks. It's bullshit. But this here is really interesting. I'm putting myself up here because what they say, maybe here, yeah. Sorry, because what they are talking about in this committee hearing, it's sorry, it's very, very interesting, very, very interesting. Hello Denise, hello Christine, Walter, cool buddy. Yeah, Justin is, yeah, okay, now you're starting to show up, now you're getting into it. All right, so let's play what happened in this hearing.
And then between September 16 and October 9 is really the only time until about a week ago that there's been no court order scheduling kind of deadlines and what to do. Because on October 9, the court issued a scheduling order setting a hearing for December 3rd on the merits of the objections to the subpoenas. And in the interim, we filed the counterclaim and intervening action, naming the committee as a party, as I talked about last time. Mr. Chairman, you're a party as the chairman of the committee, and President Kennedy, you are a party in your role as president of the Senate, because it deals with the Senate's authority and not just the committee's authority as well.
And remind our committee what court we filed these actions in and what's the appropriate jurisdiction to enforce a subpoena from the State Senate Investigative Committee.
It was filed in the Superior Court of Fulton County. We did it as a counterclaim to the petition to not enforce or declare the subpoenas invalid. That Fulton County has jurisdiction and is the proper venue because that's where the witness and the documents are in this case.
And that's why Governor Barnes filed the protective order or the objection to the subpoena in that court.
That's correct.
What is the judge that was assigned this case?
Originally, I believe it was Judge Williams. Well, no, originally it was Judge Schwall on the rotation, the random system in Fulton County. Judge Schwall decided there was a conflict, recused himself. It then went to Judge Williams, who originally scheduled a hearing and then shortly afterwards declared a conflict. At that point, Chief Judge of Fulton County, Ural Glanville, declared a county-wide conflict for all Superior Court judges in Fulton County. And when that happens, the chief judge of the county declaring the conflict will reach out to a chief judge of another circuit, and it will be transferred there. We've had that many times in election.
Every judge in Fulton County was declared in conflict regarding this subpoena that she has to show up for the Senate committee to answer questions. I was a bit surprised over that. I'm not surprised that that Judge Glanville says, "Oh, we are all conflicted here." But why? You're supposed to be neutral parties, aren't you? But no. Apparently not in Fulton County. All the judges are conflicted. So they, at least George Glanville was honest enough. Yeah, let's reach out to other chief justices in other counties.
Cases and whatnot. Then shortly after that, our current judge took the hearing, and Governor Barnes's counsel to District Attorney Willis had indicated to us and others that, you know, he was trying to get a hearing because he was concerned that she would be held in contempt for not complying with the subpoenas prior to an order. And as we explained in the hearing, you know, at the TRO, we were not going to have the Sergeant of Arms of the Senate go out and, you know, try to arrest the district attorney or anything like that. And frankly, because the legislature was out of session, that was not an option. So the judge ultimately held the hearing on December 3rd. And on December 20, she issued an order denying the petition to quash the subpoenas, upholding the Senate's authority to issue the subpoenas and this committee's authority to issue the subpoenas and to enforce them. But she did not compel the production of documents at that time. She said, pending the district attorney's explanation of why the documents are privileged, she would not compel production at that time.
Is that where we left off at your last update?
Roughly,
All right,
yes.
So by that point, the judge had issued those orders, ordering the production of the documents, gave her a date certain to provide those documents, and if they weren't provided, to give a reason why they were legally privileged from disclosure, either through attorney-client privilege or whatever other grounds she might have claimed.
Yes, sir. And
what was the date that disclosure was supposed to be made?
the January 13 is when the district attorney was to provide the basis of her objections, which were largely attorney-client privilege, attorney work product, and investigative privilege. On January 13, the petitioner made filed a response which made general objections, articulating the attorney-client privilege and so on, but also moved to quash the subpoenas again because the Senate or the General Assembly had that session of the General Assembly had ended. The new General Assembly came in on January 13. And so the argument was more or less a double down on their mootness argument, whereas before it was because the prior General Assembly had adjourned sine die. They now argued that this is a new General Assembly, the committee does not exist, and so the subpoenas were no longer valid. We argued that the current Senate Resolution 5 reauthorized the committee. Also, there was an issue of this was an issue that could be repeated and needed to be decided. The judge agreed with us on all of that and ordered the district attorney to provide once again any grounds for objection to the subpoena request, because she reiterated that they were valid, but understood that there were scope issues in terms of what was there. But like every other party, they had to explain what was the basis of the objection. The deadline for that was those orders came out February 25 because after explaining the objections on January 13, we responded, and on January 17 was when they moved to dismiss. The court issued two orders on February 25, one denying the motion to dismiss or motion to quash, and that was the one I was just talking about, upholding this committee's authority, and ordered the district attorney to once again explain her objections to the extent that, they were there. March 12 was the deadline that the court set for the district attorney to do so. On March 10, we at my firm had conversations with opposing counsel about the scope of the subpoenas and what we were looking for and so on. And candidly, given that, there's not a lot of law on this issue generally, we thought the best course of action while the legislature was.
So, is it Happy Hump Day today? Well, that's interesting. That Fani Willis decides to go on vacation on National Hump Day. Oh.
Was still in session was to at least get the documents that gave rise to the committee's formation last year and reiterating with Senate Resolution 5 again this year. So we wanted to see the documents that they had already produced in the underlying litigation that went to the Court of Appeals, where the Court of Appeals agreed on the recusal order originally issued.
Let me stop.
Yeah, for you who aren't caught up with this, Fani Willis is disqualified from the Trump case. That was, and she has appealed this all the way up to Georgia Supreme Court now. I don't think she will win, but you never know. But she really, 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 really wants to be the prosecutor in that case, even though it is. And again, folks, I really don't want to be political here, but her election campaign was about, I'm going to prosecute this man. And her re-election campaign was, I'm still going to prosecute this man. And the entirety of the Georgia justice system says, oh, fuck no, you won't. But she no. Hello, Mr. Jingles. Hello. Oh. Dun, dun, dun. There.
Stop you there. What are those documents? Because what you're telling me is she is objecting in our subpoena to documents that she has already produced in other litigation that went to the Court of Appeals.
Presumably, I can't, Mr. Chairman.
Yeah. So in the case where Ashley Merchant is the attorney, and in the case where Judicial Watch are also a party, she already lost and has to, in the FOIA request, has to turn over a bunch of documents. And this is the third case with the Georgia Senate committee. And she still fucking won't turn over, even though two courts in two different cases have said, turn it over, and she now has started to turn over the documents. She is still dodging here, wasting time and money, and not her own money, taxpayers' money.
I can't say for certain what documents that are being objected to because we've never received an itemized list of, as you normally would. So if there's an objection and it's being withheld on attorney-client privilege or work product, typically you provide, and I think the law requires you provide a privilege log, which is where you identify the date of the document, the persons, for example, if it's a communication, who are in that communication, or if it's a memo, who drafted the memo, a general subject, so it could be, legal authority, and then the basis for the objection. We've never received that. We candidly don't know what documents they're objecting to and what documents are there. So given the need, as the General Assembly winds down, and I know that there was continued interest in this issue, what we asked is just give us what you've already given opposing counsel in the litigation that led to the Court of Appeals order. Give us the documents that you have provided to the U.S. House of Representatives pursuant to its investigatory subpoena. And the committee reserves the right to issue another subpoena. But for-
That underlying litigation was where the trial court disqualified her or Mr. Wade. They had to choose one of them had to withdraw from the case.
That's right.
And she then appealed that at the Court of Appeals, and they upheld that trial court order.
Yes,
Okay, and that is now being appealed to the Supreme Court.
I believe so. Yes.
So there's documents that were relevant in that action to disqualify her from further prosecution of the 16 or 18 defendants that we know exist and that have been produced to somebody before, and you have an agreement with opposing counsel that we will at least receive those documents?
We will
with no
receive
objection?
we will receive those documents without objection.
And when are we going to get them?
That's the next step. So that agreement was reached on March 10. The petitioners did respond to the court in timely on March 12. We responded to theirs and said, look, court, we have an agreement on this. We reserve the right to issue additional subpoenas. We reserve the right to do others. And by the way, there's never been an objection to the witness subpoena to come testify to this committee. And in any prior court order, it has not addressed any objections to the witness subpoena. So it is our position filed in the litigation that those arguments are waived. And certainly we've indicated that if she comes and a question is asked that she believes is privileged, she can assert the privilege at that time as you normally do. So to now answer more specifically your question, but with that context, the agreement was reached March 10. We did not receive documents. And so on March 18, a Tuesday, I emailed opposing counsel and asked, when can we get the documents and how? Do you need us to set up a share file system or something that, for the volume of the documents? Opposing counsel responded, and said, let me check with the client, essentially. My second email, having not received documents, went to opposing counsel March 24. I did not receive one at that time. Opposing counsel indicated to me that they had a brief or a hearing that they did, and that happens. So I sent another one the next day, March 25. And once again, opposing counsel said they will once again check with their client. And on the March 24 and 25 email, I did indicate this committee was meeting. And so they wanted an update, and I just need to know what to tell you as members of the committee. So as of today, I do not have the documents. I did ask for.
Yeah, she's dodging. All the time, every time. She will fight it to the end of time to hand over documents. This is the prosecution. You remember from the YSL trial that more or less said, oh, this says guilt about absolutely horseshit. And here she is in 3 different litigations, dodging, interfering. I mean, for me, that my point of saying she's crooked Fani, I mean, it's long gone. But 3 different cases, folks. 3. How much more before they actually throw her ass in jail?
Times that the district attorney could appear to satisfy a witness subpoena, whether we issue another one or you issue another one, or it's.
And I just saw that Mr. Jingles having an Only Cats moment here behind me. Almost every stream I have, Mr. Jingles plots himself down, raises one leg, and cleans himself on stream. Yes, I mean, I know that crooked Fani has a completely different meaning in the UK. I didn't name her.
Just done by agreement based on the old one, and indicated that the committee would like to have her testify during the legislative session. The answer I got was due to the district attorney's travel schedule and court schedule, she would not be available until late April or early May.
She just happened to go on vacation the day of this hearing, where she has an active subpoena to show up and testify. Whoopsie. This is so stupid.
And that's where things stand at this time.
And remember what she did with people who she claimed would not come to testify under subpoena? She throws them in jail.
The last, there's two other things, if I could, I would just point out that this is the first time since October 8th of last year that we do not have a court order dictating what's the next step. So previously, if we were trying to get documents or trying to get witness issues there was always an order setting up a hearing or a briefing schedule that would allow the court to decide the scope of that. That appears to no longer be the case. Also intervening on March 14, so this is 4 days after we reached the agreement on the documents with opposing counsel, 2 days after the petitioner responded to the court's order on what is the objections and privilege, an order came out in litigation also in Fulton County Superior Court styled Merchant versus District Attorney of Fulton County. This is the Open Records Act issue that has been covered in the paper. In that case, the court found that the district attorney's office did not comply with the Open Records Act and its deadline of 3 days to explain how long it would take to get documents. Governments do not have to provide documents within 3 days unless they have them, but within 3 days of the request, 3 business days, they do have to explain, here's how long we think it'll take, here's what we think the costs might be. That didn't happen, and the court found that failure was not substantially justified. The second was they found there was a finding that the district attorney's office was handling the Open Records Act request in that situation differently than others. That typically the district attorney's office, and this is standard, I do a lot of open records issues on both sides. You get them, you often call opposing counsel and say, what are you really looking for? Is there a way to narrow this, et cetera? That was the DA office standard procedure as the testimony indicated, but there were no calls made to the requestor, in that case, the merchant firm. The court found that was demonstrative of a lack of good faith and further showed that there was no substantial justification to the withholding the documents. As a consequence and pursuant to the Open Records Act, the court ordered the district attorney's office to pay attorney's fees of $54,103. And that again came out March 14th. So that's where we are.
Yeah, so a court has already found that Fani Willis, in her conduct, is in bad faith. And if this had been a normal person in a company trying to do shit like this, they would be in jail. In contempt of court, they would be in jail until they complied. There's no question. But Fani Willis just happens to go on vacation. She can't give less of a fuck if she tried to. But the justice system sometimes works slow when it comes to these crooked prosecutors. But once they strike down hard. So hopefully at the end of all of this debacle, I hope we will see Fani Willis where she belongs, in jail.
If there's any questions, I'm happy to answer them. But at this point, we will continue. The next step would be if we don't get documents, and this is where I would probably ask that we go into executive session if the committee wants to weigh in on it. But just generally, the next step would be to either move the court to compel the production pursuant to the amendment or make a finding of contempt. And for the witness subpoena, I think, the committee has options there as well. I'll just leave it at that in the open session.
Questions of Mr. Belafonte from committee members? Chairman Dolezal, you're recognized first.
Thank you. Excuse me. Thank you, Mr. Chairman. Thank you, Josh, for being here. This has been going on for a year now. The DA, when we first issued the subpoena, declared in the paper that it was unlawful, when it clearly was lawful. The courts now have agreed with us that it was lawful. And I'm wondering what your advice is on how we actually get to a commitment. I know that she's saying her travel schedule is preventing that. It would appear, according to, I guess, eyewitness reports, that she's traveling with Mr. Wade again. And so do we have any ability to, I guess, distinguish between personal travel with Mr. Wade, that I don't know if that's part of why she's saying she's unavailable, versus actual official court duties? And at what point do we reach the point of either a second subpoena or enforcement of the subpoena, either with the sergeant of arms or via court order?
The existing subpoena is still on the witness subpoena is still effective. The court has ruled it is enforceable. And so whenever you have an enforceable subpoena out there and there's not compliance, you can move to compel. Now, the problem is that older subpoena had a date of last year. And during that time, so, you could, you have options, whether, again, it's to issue another subpoena or move to compel that one, or just have an agreement of counsel. And, in terms of which I would either recommend or proceed, I'm happy to answer here, but it might be best to do that in executive session.
It would appear to me, as a casual observer of this, and somebody who doesn't practice law, but, the DA has thumbed her nose at this committee. Seemingly the DA she has thumbed her nose at Georgia's open records laws. And I just have limited confidence that she's acting in good faith. And so I do believe that we may be at the point where we need to escalate this to the next step. I think you have been trying to work this out with Mr. Barnes in good
Isn't Fani in an airplane with Nathan? Yeah, it just struck me. Imagine a normal person being under a subpoena to appear before. This is not court, but it's still a legal subpoena. What happens when could you interpret that she's fleeing the country? We've seen other cases where people have gone off. We know the YNW Melly case. His ex-girlfriend left. They arrested her when she came back. Georgia Senate, here's an option. And then they can claim conscience of guilt. She left the country when she should have appeared here.
faith, and I certainly respect that.
Yeah, I know there needs to be
And I
a
think that
warrant.
he probably is
for
acting in
everything.
good faith, but I'm not sure that his client is, and that I think is probably a concern and should be a concern for this committee.
I will say that there have been a lot of filings. There have been a lot of attempts to go to the court to get resolution, and that is what has, in many ways caused the time issue. But I will also say that the court, in every time given the opportunity, has held that this committee has the jurisdiction. The documents need to be produced, and the witness testimony should occur.
Follow up, Mr. One.
Go right ahead. Sure.
As it relates to the order by Judge Ingram that the subpoena is lawful and should be enforced, where are we at with the DA's ability to appeal that? Are we still within a window of time where she can do that, or is that expired?
That is expired, and there is no appealable order at this time because because we reached agreement with them, there's nothing to appeal on the prior document subpoena. It is moot because there is that agreement. On the witness, we think they've waived the argument and long ago, and so that is that time is gone. And even then, it would take the Superior Court to decide whether to allow an appeal to proceed. But that time is gone. There's no final order right now.
Thank you.
Did Senator Tillery, did you have a question?
I was going to ask what the recommendation of counsel as to the next step as well. If you thought it would be judicial, that seems like that would be the move at this point in time, potentially even asking the court to set a date for the either in-person testimony. Or am I correct in hearing you that you already have reached an agreement on the documents to be supplied?
Yes.
Have you reached an agreement as to the date they would be supplied?
We were frankly acting under the presumption that because they've been produced to other parties that they were available quickly.
That would be my thought.
And yeah, and that's why on March 18, I kind of asked, what's the status 24th and then again 25th. So, you know, we're at the point where I think certainly we've acted in good faith in trying to get them without involving the court. I'm not sure why the documents have not been produced at this point.
Can I ask a follow-up? to
Sure.
that? If they've been produced in another matter, were those produced under seal in that other matter?
I believe there were some that may have been produced under seal, but certainly not all. And then those that, you know, there's two issues. There's the one in the litigation and then the ones that were provided to Congress. The ones that were provided to Congress, to my knowledge, were not provided under seal. And so those, again, you know, have been produced. I know typically you just keep that kind of batch ready to go.
So we're probably talking about a small number of documents that aren't already publicly available, correct?
Those that were provided to Congress, presumably, you know, any individual could get through a Freedom of Information Act request. Well, no, that's Congress. They're exempt. So, well, now with the Open Records Act applying to district attorneys and their offices, that would cover at least those provided to Congress unless there was a specific reason to withhold them under the Open Records Act. For those produced in the litigation, you know, it's kind of new area, but I would think they're subject to the Open Records Act as well.
So I guess I've kind of walked you up to my ultimate question of what would be the holdup now? Why could they not be literally provided within hours?
Senator, I can't answer that question. I just don't know. I would.
We've not been given an excuse though, right?
What we've been, you know, what we've been told is that counsel is checking with its client or their client, and that's where it lands, or that's where it sits today.
Other questions? So I'll tell the committee, I of course communicated with Mr. Belafonte, and my thought was because I'd had such a professional relationship with Governor Barnes as far as scheduling the original depositions, et cetera, that we would just reach out to him and say, when can we expect the documents? We'd reached agreement as to which documents they would voluntarily produce without raising privilege or objecting in any way. And that narrowed the scope of what we originally asked for, but at least got us going.
That's correct.
And so far, those documents have not been produced because counsel is waiting on his client, Fani Willis, to tell him when she can give us those documents. Is that the summary of the document production?
It is.
And then I also ask you, just in a professional cooperation manner, to reach out to Governor Barnes to give us a date for the deposition. My thinking was same way we did it last time. If they would agree a convenient date, we'd make sure our committee can meet and I'd issue the subpoena for that date. And his response to that was, well, it's going to be late April or May because of her travel and trial schedules. Hadn't given you a date yet?
No, but in fairness, I think they were waiting for us to propose dates either within that window or respond to that statement.
I'm going to instruct you then to give them some dates.
Okay.
In my experience as a litigator, attorney schedules are busy at the first of the week because trials usually begin on Mondays and jury selection Tuesday. So I'm going to say, let's go with a Thursday or Friday.
Okay.
That
Yeah, but she's the district attorney. She rarely actually tries cases. She has her ADAs doing all the work while she sits in her office. But I understand why they are giving her options. She really, here's a few dates. Choose one.
will lessen the likelihood that she has a legal conflict to appear in a court matter. I think this takes precedence over most of those. I mean, if she's engaged in a criminal trial where she's a prosecuting attorney, that's a different deal. But they've got over 100 attorneys in that office that can handle most motions, et cetera. Why don't anybody on the committee that knows of Thursdays or Fridays that you got a particular conflict, and I'm talking late April to, let's just look at the last week of April, the first 2 weeks of May to start with, okay? Float those dates. If anybody here knows you're on a trip or out of town and want to be here for it, let us know and we'll work around that. But give her counsel some choices and say, we will be here. Pick a date. And then we'll issue the subpoena on that date. Now, is that agreeable to everybody, or does that sound like I mean, I don't think we have to go in executive session to try to be cooperative with opposing counsel. Okay. And then on the documents, I think you're going to have to just do a letter that says, by golly, here's the date, and it needs to be before we have her here to testify so that we can be prepared to question her. So I would say 2 weeks from today or from this Friday, I mean, pick a date here, April 15th range. You look at something that's the end of a week and say, this is reasonable. This has been going on now since March the 12th, and follow up. And so that's more than 30 days from when they agreed to produce documents that have already been produced in other matters. Right? Okay. Does that sound like a fair course of action? You're the counsel for this committee, but that would be my suggestion if that suits.
I think the only question for the committee is, given the agreement on March 10, whether the committee wants documents while the legislature is in session, or if the committee would be satisfied getting them after sine die.
Well, I mean, we only got a week.
Right.
So next Friday, sine die. So I don't believe it's going to happen. Even if it gets here, we're going to be on the floor.
Sure.
So right. I don't think we'll have time for a meeting. Let's give them till April 15th to produce those documents, assuming that doesn't fall on a Saturday or Sunday. That have already been agreed upon.
Yes.
Surely she's not traveling out of, I mean, she's got a job to do here in Fulton County. She ought to be here within 30 days. And it's asked, and then if those documents aren't produced, then you got to file that motion to compel or whatever it is to get the court to make it again and ask for your attorney's fees. We're paying you for all your efforts and asking her to do stuff that the court's already ruled she has to do. And then we'll try to see if she will appear, and if not, at least then we have an opportunity to move to compel her attendance that the court's already ordered.
Okay.
All right. I have a few things in the file for committee members that Mr. Belafonte brought us this morning. I want to make sure we have in the record, and I'm going to let you mark them for us, and we'll give them to the court reporter to keep in our record. But there was an order that specifically ordered Ms. Willis to appear in response to her subpoena, the witness subpoena, and that was not appealed.
The order indicated that the witness subpoena was enforceable, but in the December of last year order, it grouped it with the document one and said, subject to the production, it doesn't address the witness one separately. My point on that one was there's not been an objection made by the district attorney on the enforceability or scope of the witness subpoena since last year.
Okay, so I'm looking at an order that's dated February 25th of 25.
Yes.
Order regarding petitioner's objections to witness subpoena that ordered her to file a detailed elaboration of her arguments no later than March 12th, or else abandon the objections to these requests on these bases. And the respondent shall have until March 21st to respond. That's us.
That's us. And that's the one where we pointed out in our response that in that opportunity afforded to the district attorney by the court, there were not objections made to the witness subpoena.
And
it was
that
focused
is
on documents.
Your document filed on March 12th, petitioner's brief in response to order regarding petitioner's objection, and then your reply. So this is the briefing of that issue.
That's correct.
All right, for our record. And no appeal to the court's order.
No.
So the next step is for us to issue the subpoena again, give them a date certain, and if she fails to appear, then we would file a motion for contempt for failing to have honored a subpoena that she's already get an order that is enforceable.
You would have several options at that point, including contempt. Yes.
Several options, including contempt. Say it with me, folks. Rice Street, Rice Street, Rice Street.
Then we will talk to you about which of those options to go.
All right.
Okay. So let's be nice guys again first. Let's reach out to her counsel and suggest either a Thursday or Friday in beginning the last week of April, or the first 2 weeks of May.
All right.
And if they will agree to a date, then we'll issue the subpoena, and I think they will honor their word. If not, we're going to have a whole nother problem. And same thing on the documents. Just say, we've hit the end of our rope. We need them by April 15th. You've already agreed to give them to us. And if they don't, then we'll have to circle back with you. I'm expecting we're going to probably plan a meeting for late April or early May, depending on the subpoena one way or the other. And then we'll tell you what to do, or you'll tell us your advice, and then we'll choose. Senator Tiller.
Mr. Chairman, I just wonder your thoughts and the thoughts of the committee. We've gone these steps several times. Would it be appropriate, and would the committee consider authorizing counsel, if a date cannot be set for appearance before May 10th, to authorize him to file a motion with the court asking the court to set the date for the personal appearance?
What do you think? Let's say they don't agree, they don't play nice, that we're trying to be professional and they won't agree to a date. Would that be an option for you to?
That would be an option. I think also that the committee could issue a subpoena setting a date unilaterally. And then they would have opportunities at that point, if they can't make it, to move to quash or whatever else. Or if we don't get a date, I think we could just ask the court, indicate it almost like a status conference, and ask for guidance from the court in an order setting a date. So that, given that we've already gone through all the objections, right? I mean, the only objection left would be something like trial schedule or something of that nature, which is why I think you've given a large window to help avoid that.
Mr. Chairman, Mr. Belafonte, the reason I'll bring up that option is if we file a motion, then we're going to have a motion to quash.
Correct.
Then we're going to have a hearing on the motion to quash. And we're going to be back in this, I think, wheel that we've been on for the past a year already. If the committee feels like it's a wise move, I at least I'm willing to make the motion if the committee wants to consider, at least for consideration, that if personal appearance cannot be set by May 10th, that we would file a motion with the court, that the court set the date for personal appearance and testimony on the matters that they've already ruled are legally binding.
Is that to basically give us a shortcut or expedite matters to do it that way?
Pending agreement with the court, of course, but it is an option to present to the court and to help shortcut that, for sure.
Senator Hatchett, you're recognized.
Yep. And this may be a conversation that would be more appropriate in executive session, but as I start, if it needs to go in executive session, you just tell me to stop. But 6.4, that I'm assuming that rule would apply here.
Yes.
And that if we send a 6.4 letter to resolve a discovery dispute and we're not able to get it, then we could actually motion for a 6.4 hearing on those specific issues. And that could be the vehicle in which to get the court to set a date for the documents and for her to appear.
That is another option.
Okay.
Yes, sir.
I'll get ahead of you, Mr. Chairman, but if you're comfortable with that, I'll make that in a form of a motion.
Basically, it would be if they don't voluntarily agree to select one of these dates in the next, the end of April, the first 2 weeks of May, to ask the court's intervention to set the date.
Set the date.
All right. I'll accept that as a motion. Anybody want to second that? Got a second by the vice chairman. Any discussion of that course of action. All right, all in agreement with that, raise your hand. 1, 2, 3, 4, 5. All opposed? 2 opposed.
Yeah, and the 2 opposed are the Democrats in this Senate committee. I've been covering 4 or 5 of these Senate committees. I only heard one of them speak once. Other than that, they are just there to obstruct. And for me, what they are doing here, after all this discussion, is saying, more or less, they are saying, we believe Fani Willis is doing the right thing. That's what they are doing.
And Mr. Chairman, I have another motion I'd like to make second to that, if you
Let's
don't
hear
mind. Should we end up in the position that we have to move forward with forcing a hearing because we can't set one by agreement, then I would move that we instruct counsel to request all fees for all time involved in anything concerning his cost, attorney's fees, for anything concerning the matters of appearance and document production after May the 10th.
I don't even think we need a motion for that. You're going to do that, aren't you?
Sounds like it, sir.
I mean, why would
Yeah.
you?
No,
We're paying you.
Yep.
Yeah. Yeah, you don't have to have a formal motion. That's your instructions. Make her comply, and if she won't, make her pay for your fees for making her do what the judge has already told her she's got to do.
All right.
Okay, because Fulton County has already shown that they'll do that if they snub their nose at open records requests. So this seems to me more important than an open records request, an actual subpoena.
Okay.
That's been enforced by the court's order.
Right.
Yes, Senator Gooch.
I'm
you're
going to
right.
ask a question. I think I may know the answer. What would typically happen if a district attorney like Ms. Willis issues a subpoena and the person that she issued that subpoena for just ignored it and neglected to appear?
That person could be held in criminal contempt.
Okay. Arrested?
Could be.
Okay.
Oh, there it is. There it was. Yeah, just making sure in front of the cameras, this might be. This is what she would have done to somebody disobeying a subpoena. File for contempt of court and then have them arrested. Yeah, that is a viable option here. Now, I see in the chat that they are kicking the can further down the line. This is politics also, because they know Fani Willis will play every card she has to make people feel sorry for her, including but not limited to the race card or the woman card or whatever card. And so they are effectively removing that by, as the chairman said, let's be the nice guys again. And if they still don't play ball, then it's on them.
Other questions from committee members? Senator Dolezal.
Mr. Belafonte, what is our legal obligation to show deference to her personal travel schedule? Because I suspect that after a year of seeing her thumb her nose at this committee, I made a couple notes of what the court said in the open records case. They called her office openly hostile and substantially groundless and vexatious. Mm-hmm. You overlay that with the odor of mendacity comments the other judges have had, and I think that what we have here is an individual who thinks she's above the law. And I don't think that the people of Georgia want this committee to wait for her to decide that she wants to appear based on her either her travel schedule, Mr. Wade, her travel schedule otherwise, or the court thing. I think we would have obviously understanding of. But what is our requirement to defer to her personal travel schedule?
There is not one. It could be a ground to quash the subpoena and then the court could decide how to proceed with that. But the committee has no obligation to, unless there's a leave of absence filed in a case or something of that nature, which we don't have in this context. But to answer your question, there's not one.
Thank you.
Okay, I'm going to mark the documents that the orders regarding the production.
Yeah, and what he said there is absolutely correct. Courts have found that these their refusal in the Open Records Act are done in bad faith. They are using quite harsh language, the courts, and so she's really, really running out of options. And I can't wait for when these documents are actually being presented in a legal setting.
Documents and the responses and reply briefs that
They
record,
probably
we
know
can have
she's
that
in
our
the
record.
airport.
We also have in our folder a draft of minutes from our last meeting that we need to approve. If y'all take a minute to review those. This was our February 20th meeting, our organizational meeting, and we got litigation update from Mr. Belafonte at that meeting as well.
Motion to approve.
All right, we've got a motion to approve. Is there a second? Second by Senator Kennedy. All in favor, raise your hand. Any opposed? All right, those pass unanimously. All right, having done that, that will conclude our business. We will wait to hear from you as to whether or not you're able to reach an agreement as to the date that she will appear to respond to her witness subpoena. And as soon as you get the documents, please share them with the committee.
All right.
And with that, we are adjourned. Thank you very much.
Thank you.
Yeah, I mean, even though this sounds that they are giving her leeway in some shape or form, in political terms, as politicians as they are, this is quite harsh. You don't usually see this. Now, I do believe Chairman had a press conference of sorts. Or, let's see here. Yep.
Good morning. How you doing? I'm doing just great. Thank you.
Thanks for your time. Give network here 1 second. Usually they're the fast ones. Yeah. Yeah, I thought you wanted to. Yeah, thank you. I got you.
All right.
All right. Let's see what we got. All right. Okay, so just remind us again on the document side of things, what exactly is it that you guys had asked for?
We had a subpoena that asked for a lot of information about the operations of their DA's office, their budget, how they went about hiring private counsel like Mr. Wade, and what the budget was, how much money they were spending for that outside counsel, special counsel they called Mr. Wade in this case, and just the manner of the budgeting of their office and how it operated. And not details about any prosecution. We're not trying to get into how she's going about or was going about prosecuting certain defendants. But we wanted to know about the processes and a lot of budgetary information, and she refused to give that to us. Of course, the main thing was we would like to hear from Ms. Willis. We've invited her to come to explain her conduct and the actions that she's taken in numerous cases in Fulton County, and she's just refused to talk. So that required us to file the subpoena. She objected to the subpoena. The court ordered her to comply with the subpoena and verified that our committee does have investigative powers and the right to subpoena documents and testimony. And after that order has been given, she still hasn't given the documents and hasn't agreed upon a date to come testify. So we wanted to have an update from our legal counsel, who's representing the committee, as to exactly where this process stands and why it's taken so long. What are we going to have to do to get her to comply with the law? He did update us this morning. You may have been there at the meeting, and also made mention of the open records situation where she had other people that had requested open records She refused to give them. Court had a hearing on that and ordered her to produce the records and pay attorney's fees of $54,000. So we're frustrated, the delays, the incessant, one of the members said she keeps thumbing her nose at not just this committee and the state Senate, but all other attempts to get her to cooperate or produce certain documents that people feel are relevant. So we're going to continue pushing until she does, and he just gave us the course of action. And we're trying to do it in a cooperative manner. We're going to reach out to her counsel, and we're going to suggest a few additional dates that she could comply with the subpoena to come testify to our committee. If we can agree upon the date, that's what we'll do. If not, we'll go back to court and ask the judge to set a date for her to come testify for our committee. And also to make sure she produces these documents that we think we've reached an agreement that she will produce certain documents, and certain ones we agree not to push forward at this time. And hopefully we'll resolve this and she'll begin to respond to the legal process like she expects defendants in her court to do.
Right, and again, as Senator Goldwasser mentioned, there are times where people don't respond to subpoenas or document requests, and there are consequences to that. What could the consequences be here, all the way from contempt up to, are you guys prepared to arrest her?
Well, we wouldn't do the arrest, but the judge can issue an order to confine her. Yeah, you can be confined in jail as a punishment for contempt if you willingly snub your nose at a court's order. And they can be fines. So you will just have to see what the Superior Court of Fulton County would choose to do to force her to comply with their orders. She is not above the law. And I think that there are legal processes to force her to comply. And yes, that does include confinement. And I'm not threatening that. That's up to the judge to do if she fails to comply. But so far, I mean, this has been going on now for many months. We issued our subpoenas back in September of 24. We're now 6 months later, and we haven't gotten her to comply, even though the judge has ordered it. And, you know, we're fed up with that. We've had enough, so we're going to take the next step. We're going to try one more time to reach out to her and let her and her attorney agree upon a date that is convenient with her and convenient with us in the next few weeks. We're going to aim for the end of April or early May because her attorney said she had travel commitments and that she had court commitments that would keep her unavailable up until that time. So that's about another month, but at the end of that time, we'll be out of patience, and we hope they'll agree to appear. If not, we'll go to court and we'll ask the court to force her to obey our subpoena.
Yeah, you talk about travel plans. We saw, obviously, I know you saw the other day that it appeared she was traveling with Mr. Wade. Given that this all started with the way he was named, at the top of that case, you mentioned thumbing her nose at this. Do you think that's what she's doing, just by continuing to be and spend time with Mr. Wade?
I don't know, and I'm not going to get into the name calling and accusations. People have travel plans. It doesn't matter if she's traveling with Mr. Wade or her mother or anybody else. I mean, that's not our concern, our business. And I'm sure she may have some time off. Attorneys file leaves of absence when they're going to be away from court and unable to appear. And I'm not going to judge her or criticize her of what the purpose of her travel may be. But she just needs to give us a time when she's going to be in Atlanta and able to come testify.
I think this is the most important question. Donald Trump was able to get back into the White House despite all the legal troubles that we're facing during the campaign. This case appears to have unraveled quite a bit. Is this still worth your time?
I keep saying, this isn't about that case. This is not about trying to interfere with her prosecution of Donald Trump or any of the other defendants that she went after. That's her job. The courts have slammed her on that pretty much every time they turn around, that she's had inappropriate relationships and conflicts of interest and, has been required to either her withdrawal or Mr. Wade. But that's not our problem. We're looking at the underlying conduct and the public confidence in the judicial system, in the criminal justice system, and what actions should be permitted and not permitted by district attorneys or other prosecutors. And are there legal changes that we need to make to restore confidence in the public of the nonpartisan approach to criminal justice? So I'm not getting into her prosecution. I think the courts have pretty much put an end to a lot of that, but that's not the Senate's mission here, or not our purpose in investigating misconduct by prosecutors.
Thank you, sir.
I've got another meeting I've got to. Thank you all.
You got it, man. Of course. You're off the shoulder.
All right, so that was the hearing where Fani Willis keeps dodging her obligations towards Fulton County, towards the Georgia Senate. She's losing everywhere. But she's still trying. So, in my opinion, when you try to avoid turning over documents, turning up to testify month after month after month. Yeah, I know presumption of innocence, but we also have a thing called consciousness of guilt. What's in those documents that is so absolutely damning against Fani Willis that she is now in an immediate risk of contempt of court? Yeah, defendants are allowed to remain silent, but they just can't ignore court orders, which is what Fani Willis is doing. All right, that was about Fani Willis. Let's go into the YNW Melly case. Dun, dun, dun. All right, let's talk about the YNW Melly case. And there has been two updates. One from Raven Liberty, and one from YNW Melly himself through his attorneys. Let's start with the Raven Liberty one. Dun, dun, dun. Boom. Let's get this up there instead. Motion to vacate stay issued February 16th, 2024, and or modify allowing the defendant's motion to dismiss charge of witness tampering to be resolved. Yeah, this is Raven Liberty, Mr. Melly's attorney, who has been since December of 2023 under investigation for witness tampering. Now, this witness tampering, as for you who have been here during my coverage of this case, this witness tampering thing is something that the prosecution had as a secret up until mid-December of last year, when they got a notice from Google, I believe, whatever, because the prosecution sought and got everything in Raven Liberty's, attorney Raven Liberty's iPhone or other Apple devices. So not Google, Apple, the Apple Cloud thing. Everything in it. Everything. Because they claim she aided Mr. Melly in witness tampering. And go back and watch the last time I covered this, because it was hilarious to see the judge really, he was not happy with the prosecution. So he ordered them to hand over what you got under this, whatever it's called, so I can decide what will be handed over to the defense or not. Because they claimed, it's work product. Yeah, you've been doing it for over a year. At what point, either it's a work product because you're close to a prosecution, or after a year and you still haven't done anything, then it's no longer a work product. But let's go first with what she has to say. The defendant, YNW Demons, by and through the undersigned attorney, hereby moves the court for an order vacating the stay issued February 16th, 2024, or in the alternative, modify the stay for purposes of resolving Mr. Demons' motion to dismiss, and states the following. And this is the witness tampering case, not the murder case. On February 16th, 2024, the state moved for an order on the pretrial admissibility of certain discovery that was used in the state of Florida versus Demons, this case number. The court entered an order admitting and excluding certain Snapchat, Gmail records, Apple iPhone records, and promotional video, all which is evidence in the homicide. This order was immediately appealed by the state of Florida. On February 16th, 2024, the state of Florida was also granted a stay of trial proceedings and extension of the speedy trial. It is this order that the defendant now seeks to vacate. On May 2nd, 2024, the court, after hearing, entered an order modifying the stay to allow all discovery, deposition, and discovery-related litigation to proceed while the appeal was pending. The order issued May 2nd relied on Bryant v. Blunt, stating that the, quote, purpose for providing a stay of the case in the event of appeal is to prevent the state from having to go to trial without the benefit of materially helpful evidence because of an erroneous dismissal or suppression order entered by the trial court. That is not the case here. The Snapchat, Gmail records, and iPhone records from 2018 have absolutely no relevance to a witness tampering case that is alleged to have occurred in 2023. Florida appeals states in part that, quote, a stay entered by a lower tribunal shall remain in effect during pendency of review unless modified or vacated. It is clear upon the sworn testimony of Detective Garrett Steele that there are no disputed issues of material fact in the case, and the undisputed facts do not amount to a prima facie case of guilt. It is unjust to allow the stay to remain in place when it is clear that the state of Florida cannot maintain a criminal action against Mr. Demons for violation of Florida statute this. Wherefore, the defendant, Mr. Demons, requests an order of this court vacating the stay entered February 16th, or in the alternative, modify the stay to allow the defendant's motion to dismiss to be determined. So this is in the Mr. Demons, or Demons, witness tampering case. They are just sick of it. Hey, what's going on here? Because the stay was for things the state have had in their possession since 2018. And they are in front of a different judge now, who might not have the patience with the prosecution as the previous judge had. The previous judge, who was the judge in the first YNW Melly trial, he was at the end of his ropes as well. And if you don't know, the first prosecutor in the YNW Melly trial got yeeted. She was not allowed to prosecute this case anymore because of misconduct. Then they had the lead detective in this case had to admit in open court that he asked another cop to lie for him in a matter regarding this case. It was his Melly's mother's phone, which this lead detective, while they were interviewing her outside of his jurisdiction, he just snatched it and then asked a cop to lie for him. Yeah, that was really, really interesting. Oh, sorry. Now, what is this next one? I'm going in. This is from Bryson Boom Paul. This is filed on March 24th. Melly's attorney, Daniel Aronson, filed a motion to reveal state's intrusion on defendant's right to due process, client confidentiality, attorney-client relationship with Broward County clerk on Monday afternoon. The 9-page document, Melly and Aronson, argues that the state's handling of attorney Liberty's Apple account data constitutes a severe violation of due process and attorney-client privilege, necessitating immediate court intervention. Melly's defense requests the return of all material seized from attorney Raven Liberty's Apple accounts and disclosure of all related evidence, including the protocol used to separate privileged information from prosecutors. Without access to the seized materials and a list of involved witnesses, the defense cannot fully determine the extent of the intrusion or prepare an effective legal response. Melly's defense claims the state obtained Liberty's Apple account data without notifying the defense for nearly a year, despite its potential impact on attorney-client privilege and the defendant's right to a fair trial. The court ordered the state to provide discovery materials related to the seizure, but the state has yet to comply, raising concerns of prosecutorial misconduct. Yeah, I covered this hearing when the judge told the prosecution, hand the stuff over to me, so he can determine what will happen to it. And he gave them a 3-week something. Now let's get into the actual papers. Hold on here while I try to bring that up for you. Dun, dun, dun. So we can read it together. Thank you to Bryson for publishing. Let's see it. Boom, boom, boom. Bum, bum, bum. Are we on the right one? Yep. I hope so. Oh, wrong one. Here it is. So this is the latest development in the YNW Melly case, and it is regarding the, in my opinion, absolutely horrifyingly bad warrant on Liberty's Apple iPhone data. Remember, they got free range from some schmuck judge. We don't know what they told that judge in order to hand over information, Raven Liberty, an attorney. Because remember, they asked for everything from 2018 going forward. Melly is not her only client. There might be tons of attorney-client privilege information in her Apple iPhone, iPad, and everything. Tons. And some judge allowed it. But let's read here. Motion to compel discovery, or in the alternative, motion to reveal extent of state's intrusion on the defendant's right to due process, client confidentiality, attorney-client relationship. Comes now. The defendant, by and through undersigned counsel, and moves this honorable court pursuant to Rule 3.190, Florida Rules of Criminal Procedure, to issue an order requiring the state as follows. 1. To return all property seized from defendant Jamel Demons regarding attorney Raven Liberty's Apple accounts. 2. Provide copies of all materials in the state's possession obtained from attorney Raven Liberty's Apple accounts. 3. Provide notice to the defense of any and all documents received that may have a bearing on the attorney-client privilege. 4. Provide the protocol that was used to segregate the information provided to the state under the search warrant for Attorney Liberty's Apple accounts from the prosecutors currently prosecuting the defendant in this cause. 5. A list of all witnesses who were involved in obtaining the search warrant for Miss Liberty's Apple accounts and that reviewed any evidence seized under said search warrant. 6. Any and all documents, including search warrant affidavits, police reports, and findings in relation to the search warrant, seizure, and review of Miss Liberty's Apple accounts. As grounds for said motion, the defendant states the following. On February 8th, 2019, the state filed an indictment charging the defendant with 2 counts of first-degree murder. Yeah, this case has been going on for 6 years now. 6 years. On March 5th, 2019, the defendant entered a plea of not guilty, demand for jury trial and demand for discovery, pursuant blah, 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 blah. On April 16th, 2019, the state filed its notice of intent to seek the death penalty. On October 17th, 2023, the state filed an information charging the defendant with tampering with a witness in a capital felony, directing the activities of a criminal gang, solicitation to commit tampering, and conspiracy to commit tampering, the quote-unquote tampering case. On November 9th, 2023, the defendant entered a plea of not guilty, a demand for a jury trial, and a demand for jury trial under the tampering case. On January 24th, 2024, the state filed its initial discovery response in the tampering case. 7. On December 27th, 2024, the defendant filed a motion for a hearing to determine potential conflict, setting forth that a member of the defense team, Attorney Raven Liberty, was informed by Apple that on December 13th, 2023, her Apple account information had been provided to the Broward County Sheriff's Office pursuant to a search warrant. Over a year later, she was made aware of it. On January 6, 2025, the defendant made an tenuous motion to compel the state to provide the affidavit to the search warrant on Raven Liberty's Apple accounts. The court ordered the state to provide the affidavit the following day, January 7th. On January 7th, this court modified its previous order and ordered the state to provide a copy of the Apple search warrant to the court to be reviewed in camera on or before January 14th, 2025. On February 7th, 2025, this court provided all defense counsel, as well as the defendant, a copy of the unredacted search warrant. I believe we went through that one, and it's absolutely horseshit. Absolutely horseshit. So this will be in the YNWMelly playlist. I have that playlist if you want to go back and watch me go absolutely bananas over that search warrant. 11. The unredacted search warrant revealed that every aspect of Miss Liberty's accounts and every bit of information contained therein was provided to the Broward Sheriff's Office pursuant to the warrant. 12. The state never revealed during approximately a year's time the fact that they had in their possession the contents of Miss Liberty's Apple accounts. Only after the defendant, on December 27th, brought this matter to the court's attention, did the state acknowledge that Miss Liberty's accounts had been seized. 14. The state has contended that no other member of the defense team of Mr. Demons is under investigation or had any warrants issued against them. 15. However, in a federal civil proceeding involving the defendant, attorneys for the Broward Sheriff's Office also indicated that the defense team investigator, Reggie Hope, has also been subjected to similar warrants. The prosecutors lied. In open court and in filings, they lied. Welcome to Florida. On February 18th, 2025, this court granted the defendant's motion to compel discovery. The state was given 20 days to comply. The state has yet to provide any discovery subject to this order. That being all information, documents, witnesses, and evidence in relation to the search and seizure of Attorney Liberty's Apple accounts. The state numerous times has asserted that these discoverable materials are germane to defendants tampering with the witness charge. That is now part of this case. Argument. Although this court has been reticent to involve itself in the determination by the defendant as to whether he still would like to have Attorney Raven Liberty represent him, as the state has said, based upon the information that they have, that there is a conflict. Conflict is but a small part of this motion. Rather, the seizure of Miss Liberty's Apple accounts not only raised the issue of conflict under the Sixth Amendment of the United States Constitution, but also of attorney-client privilege under the Sixth Amendment and effective assistance of counsel, along with due process rights under the Fifth Amendment to the United States Constitution. Undersigned has been unable to find any cases in the state of Florida exactly on point to the situation herein. Yeah, that's because no other prosecution has ever been this fucking retarded to do something like this. Of course, there is no case law when this is so far away from fair trial, from due process. This is miles away. And folks, I don't care if Melly did it or not. And neither should you. What you should care about is because if they do this to him, they will do it to others. But now we know because Melly has money, can hire the attorneys who will find these things out. So how many others are in prison, are on death row in Florida because of prosecutors doing this? How many? All of them? We don't know. Rather, the actions by the state in this case appear to be such an anomaly of bad faith prosecution and government misconduct that the courts apparently have not had to rule on such egregiousness. What is clear from both state case law and federal state case law that a hearing will need to be conducted by this court to determine the nature, extent, and prejudice to the defendant both under the Fifth Amendment and Sixth Amendment of the United States Constitution. In State v. Kelly, the prosecutor and investigator went to the defendant's house during the middle of the trial in order to ascertain information to use against the defendant at trial. The next morning at trial, the defense moved to dismiss the charges. The court conducted a hearing in which both the prosecutor and the investigator were examined and cross-examined. The case was ultimately dismissed due to the continuing prejudice of the defendant's rights to due process and effective assistance of counsel. The idea or the requirement that the court get involved in determining whether the defendant's due process, client confidentiality, and effective assistance of counsel have been violated, requiring a hearing on the same is not new. In United States v. Levy, the court conducted a hearing at which the government produced the testimony of several DEA agents and the prosecutor. Also, the court required the government to produce the entire DEA case file. In United States versus M. Neal, the court conducted an evidentiary hearing on the defendant's motion to dismiss due to government invasion of their attorney-client privilege. At the hearing, agents, taint team prosecutors, and the prosecutors assigned to the case testified. Prior to the hearing, the defense had the ability to review all of the material in the government's possession. The case of U.S. versus Valencia Trujillo is another example of when due process, client confidentiality, and effective assistance of counsel, when impacted by government search, warrants a hearing to determine the extent of both the Fifth and Sixth Amendment violations. In this case, along with other testimony, the court heard testimony from 2 of the taint team members. And in United States versus DeLuca, the district court held an evidentiary hearing on DeLuca's motion to dismiss on June 4th, 2013. The court heard testimony from former AUSA guard, Agent Stelly, AUSA Stoddard, DeLuca, and the FBI computer analyst who initially segregated the data for the filter team. From these cases, it is clear that this court will have to conduct an evidentiary hearing to determine the extent of the intrusion into the defendant's Fifth Amendment and Sixth Amendment rights. However, in order to have a meaningful hearing, the defendant needs to be provided with all the material that was seized. Of course, in order to be able to determine whether there has been or not has been a violation of due process, effective assistance of counsel and client confidentiality, all the witnesses, state attorneys, and agents or officers who have any information or dealings with the seizure of these materials must testify. Without a list of who these witnesses are, the defense will be unable to call them to testify at hearing. In United States versus MNeil Supra, after the defense was able to review all the material seized by the government upon demand, the government returned the same to the defendants. Without being able to review all material seized from Miss Liberty's Apple account, the defendant will not be able to make such demand. The defense has an affirmative duty, once it knows that confidential communications are in the hands of the government, to raise the privilege. Again, without seeing all the documents and evidence that was seized, how can the defendant make that specific demand? As court noted in MNeil Supra, under Weatherford and Kelly, 4 factors are relevant as to whether an alleged intrusion into the attorney-client privilege offends the Constitution. 1. Whether evidence to be used at trial was obtained directly or indirectly by the government intrusion. 2. Whether the intrusion was intentional. 3. Whether the prosecution received otherwise confidential information about trial preparation or defense strategy as a result of the intrusion. And 4. Whether the privileged information was used or will be used to the substantial detriment of the defendants. It was indicated by the state that a separate team of prosecutors or law enforcement agents reviewed the material seized from Miss Liberty's Apple account. As the court noted in MNeil, quote, "It is clear that the government's affirmative decision to invoke these procedures constitutes a per se intentional intrusion." Again, citing to Weatherford and Kelly. Therefore, even prior to a hearing on this matter, the first 2 prongs of the Weatherford-Kelly test, whether the evidence to be used at trial was obtained directly or indirectly by the government intrusion, and whether the intrusion was intentional, have already been satisfied. Certainly, a hearing will determine the 3rd and 4th factors of the Weatherford-Kelly analysis and will have to be had. Wherefore, the defendant requests this honorable court grant this motion and require the state to provide the information requested herein, so that the defendants may effectively examine the witnesses that will be required to testify at the evidentiary hearing that will be required. And signed and everything. And this case is so stupid. Because if you watch the first trial, they have evidence. Is it enough for a conviction? Don't know. But there's no question about if they have evidence to present to a jury without being assholes, without misconduct. But in this case, they seem to do it because they think I don't know. The Constitution doesn't apply to them. For me, it is very clear that Mr. Melly's constitutional rights have been violated. And now in this, we find out that Miss Liberty is not the only attorney that has been subject to a search warrant. even though the prosecution in open court stated that she was the only one. They lied. They seem to not be able to not lie in open court as prosecutors. It is yeah. But this has now been filed with the court. I am looking forward to the next court date. I'm not entirely sure when it is, but it will be interesting to see the prosecution's reply to this. How they will get away with, we know we lied, Your Honor, but ignore that. I mean, this is not in front of Judge Bev or Judge Gull. This judge, whose name escapes me now, really, really have been adamant in the prosecution sought the death penalty. All the rights of this, every right is on for the defendant. If there is a question about who do we lean to, it is in favor of the defendant. But we don't know. We now know there are more search warrants out there against Mr. Melly's defense team. We now know that even though under court order they are supposed to hand shit over to the defense, they haven't. They haven't. And it's infuriating. And I got raided by Dali. Thank you so much. Thank you so much, Dali. What about my voice? Yeah, your voice is soothing too. Your voice is soothing too. All right, so that was the YNW Melly update. Now let's go into the Adelson case. For you who are completely new to the Adelson case, Donna Adelson is charged with the murder of her former son-in-law. So far in the Adelson case, the hitman convicted, the middle person convicted, Charlie Adelson convicted. Charlie Adelson was determined by a jury that he paid for this and was involved in the murder of his former brother-in-law. And now it's time for Donna Adelson, the matriarch of the Florida Adelson family. She's been in jail for over a year. I've been covering this case for almost 2 years now. And she had to replace her entire defense team because she chose originally to have Charlie's attorneys as her attorneys. But those attorneys kind of forgot to tell the court that the waiver that Charlie Adelson was supposed to sign was never signed. Judge was not happy. So it started out with the lead attorney being yeeted, and then the rest of his team yeeted as well. So now she has an entire new defense team. And what have they done? This is a kind of a, let's see here, where is it? Dun, dun, dun. Dun, dun, dun. There it is. Dun, dun, dun. Ah, I forgot. I have to do a swoop. Yes, my swoop is the Norwegian fire farting dragon. You cannot sneak up on that from behind. All right, this is the latest hearing. Dun, dun, dun.
Ms. Dugan.
Your Honor, the first thing I want to address, I think it was last week before, Your Honor, issued the order concerning the prior investigator. When we were first before the court in December, we were told that the defense would have the benefit of what already occurred. I certainly understand the conflict issues, but our client is being punished and prejudiced in her ability to defend herself, not based on her actions, but on the actions of her former attorneys. It's our understanding that one of the things that the investigator did was travel down to South Florida, take pictures, identify times of travel. We don't have those materials, and we're asking for an exception to the court's order to get those materials, not his reports that he generated from interviewing individuals.
The raw materials.
Just the photographs and those specific notes. And if we want to do it in process where Your Honor makes sure that that's all that's being transmitted to us, fine. But otherwise, our client's going to have to go to the expense of hiring somebody to do that same exact task.
Problem with this, Mr. Zellman, is if in any way the conflict bleeds over, that compromises the trial itself. The whole point of stopping the trial because of the conflict was not to have to do this a second time. Your client did select who she wanted to represent her. There is a conflict issue tied up in that. At this point, untangling all that is ensnared by the conflict presents more issues. Does the state wish to be heard?
I would defer to your ruling since you did the in-camera review, Judge.
As to whether any raw materials that were obtained by the investigator could be used, I will give this additional consideration. However, any report that he has made that remains subject to the ruling, him assisting with the defense remains subject to the ruling. Other matters that you need to address, go ahead.
Yes, Your Honor. In December, you entered the order setting court proceeding dates and procedures.
Yes,
I've conferred with the state, and we have a few requests for changes in those.
go ahead.
With respect to the discovery deadline, which is now set for Wednesday, April 30th of 2025, we would like the order to be amended, if Your Honor agrees, to say that deadline will remain. The exception would be if the parties agree to depositions outside of that date. We've had some problems with getting some depositions scheduled when everyone is available. We already have one set in May 14th, so we would like just the opportunity to hold depositions past April 30th if everyone is in agreement.
Ms. Dugan.
No objection.
Very well, the deadline will remain in place. As to whether this would affect any motions that would need to be heard, that would occur once the issue presents itself, but you may schedule the deposition if you need to.
Thank you, Judge. We also were requesting that because of the discovery issues, that we extend the pretrial motion filing deadline to May the 9th and to presenting the final witness and exhibit list to May the 13th. And the state had no objection to that either.
Ms. Dugan.
No objection.
Those dates then will be moved as requested by the parties.
Thank you, Judge.
Any other matters the defense needs to raise?
Your Honor, we had previously submitted a proposed order concerning the wealth evidence, and we had
Yes.
addressed it by email with your judicial assistant in the state. And Your Honor indicated that we would address it here this morning. The purpose of submitting that is so that there is complete clarity on the court's ruling, that there's not an issue. We are not trying to get into a situation where we're having to seek a mistrial.
As to that, I reviewed the original order and also what was proposed. They didn't exactly coincide. Is there something in particular that you believe needs to be clarified based from the original order?
I don't think that there is. I think that there's a difference in opinion as to what the court's order meant.
I reviewed the transcript on that as well, and I believe as it went to the state presenting any evidence of motive, or specifically that
Mrs. Adelson was somehow involved with the offer of money relating to the, I believe, relocation of the children, that evidence would be permitted as far as any general evidence concerning her money, such as what her net worth was on a particular date. That was not going to be presented. But again, as it relates to presenting evidence on motive, that would be presented. What is unclear about this?
I think that clears up the potential confusion, Your Honor.
All right. Ms. Dugan, do you need to be heard on this point?
No, sir.
We've already filed 2 additional motions in limine. There are at least 7 more that we are still working on, and we are hoping to get filed in the next few weeks. When we were here last, I had indicated that there was another motion to suppress. I'd hoped to file previously, but given the depositions that are scheduled, I want to wait until after those, in the middle of April, to get that filed, just to solidify some of the testimony. So that will be filed before the end of April.
Right. As to the motion in limine concerning the use of the book for impeachment, are the parties capable of handling this matter today?
I'm not prepared for that.
We can, I believe that the state's stance is that much of that has already been heard before as well, but we could get with your assistant and set a time for that to be heard.
Go ahead, so that way that matter can be resolved somewhat quickly, I believe, compared to the other motions, but there should be, look at the calendar. Probably handle either a 30-minute or 45-minute motion on that. Even this week, if all parties are capable of handling it. State defense.
Just looking at my calendar, Your Honor, it looks like I'd be available. I could make myself available almost anytime Thursday and anytime Friday.
Ms. Dugan.
That should work. Maybe Thursday afternoon, we could set something. If I could get with Ms. Kappelman, and we'll email Lynn this afternoon, would that be okay?
Contact Lynn to see what time on Thursday we can go ahead and address the issue
Yes, sir.
Yes, sir.
of the book.
Yes, sir. And then lastly, on the venue issue, we have the materials from our expert. I was hoping to file it last night, but still finishing putting all of the materials together. We also have spoken with the state about their position on filing those materials under seal. That motion, file under seal, and proposed order is already done. I can submit those today when I get back to the office. And then the materials themselves, I'd like to say tonight, but realistically, probably tomorrow.
Please file them as soon as you're capable. If there is no dispute from the state concerning whether it's under seal, you may do so.
Ms. Kappelman indicated yesterday that there was no objection from the state, so that portion's already resolved.
Very well. Do the parties need another case management before we get to the more substantive dates and the orders?
The state does not.
Your Honor, at this point, I don't think that we do. If something arises that we cannot work out amongst ourselves and we need to get court intervention, we will certainly contact your judicial assistant.
Well, let me briefly look at the order that was previously set. We're setting all of the dates and deadlines.
This is a simple scheduling hearing, and so
Looks like the pretrial
It's
is
an update.
already preset by order for 5/16 at 9 o'clock. That will be the next date in which the matter will be addressed outside of any other motions. Unless either party has anything further to address, we'll be in recess for this case.
No, sir.
Thank you, Your Honor.
That is the conclusion of the hearing. Have a good afternoon, everyone.
All right. Yeah. Not much, but it was an update on the Adelson case. The Adelson case is scheduled for start. Well, it starts when it starts. Melly retrial is scheduled for September. I will be in the United States in September. I will be first in Utah, September 3rd to September 17th. And then I will travel to Miami on the 17th and stay there until the 24th. And hopefully I can get myself into the courtroom of the YNW Melly trial, unless this judge decides to kick it out. All right, folks, that is what I had for you today. We started with the first hour and a few minutes with the new thing about Fani Willis. She's on vacation with her ex, which has never been an ex, Nathan Wade. That saw the Georgia Senate Commission hearing, where they are more or less on the end of the ropes and saying their option, a viable option, if she doesn't stop fucking around, that she will find out that criminal contempt of court is an option. And then I read to you the updates on the YNW Melly trial, and now latest, for as a soothing thing, we saw the latest in the Donna Adelson. That is what I had for you. Everybody, thank you for being here. Thank you for allowing me to do this. Thank you guys over at Rumble. Thank you over at X. And thank you here on YouTube. Thank you so much. And well, I don't know if I will produce anything tomorrow, but if I will, you will be the first to know. Okay. Thank you again. And hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Bye-bye.
Sail the raven waves, brothers.